Good morning and welcome to an oral argument session before the 5th District Court of Appeal. I'm Judge Jim Edwards. I'll be presiding. With me on the panel are Judge Scott Makar and Judge Joe Boatwright. And the case we have before us at this time is case 23-330, D'Angelo George Robinson versus the state of Florida. Each side will have 20 minutes. If you have something that might make noise, please make sure it's muted. You'll see we have a clock that has lights on it. Your 20 minutes is your entire time. We typically reserve 5 minutes for the appellant's rebuttal. If you want something different, just let us know. The yellow light will come on when you're into your rebuttal time. If it looks like you're not seeing that, I may point that out to you or remind you. And with that, we're ready to proceed.
Good morning. May it please the court, counsel. Robert Pierce on behalf of D'Angelo Robinson. We'd stick with the 5 minutes of rebuttal time. Good morning, and again, thank you for the opportunity to discuss this case. Now, before diving, Mr. Robinson appeals from the denial of his motion for discharge under Florida's Speedy Trial Rule 3.191. And before diving into the heart of that issue, I think there's two important pieces of context that I need to set out up front because they're so integral to the discussion of the issues. The first of these is factual. So there were two teams involved in the arrest of Mr. Robinson in November of 2015. There was the takedown team. This was the FDLE SWAT team, the Special Operations Group, that was sent down for the express purpose, the sole purpose of executing this arrest warrant out of Duval County. This is the team that physically took Mr. Robinson to the ground, and that will be important later. The other team was the support team. This is the team with the Suwannee County officers on it that was set up about 50 to 60 yards away from where the takedown eventually occurred. Now, for whatever reason, the state did not call any member of the takedown team at the hearing below. Instead, they only called two witnesses, and both of them were from Suwannee County. They were from the support team. And the reason that I point this out at the outset is because the absence of that evidence, the fact that we don't have any testimony from that takedown team, is effectively fatal to every challenge that the state has raised to the presence of the four Melton factors, because there is only so much that the testimony of the support team can do. And what it cannot do is exactly what the state needs it to.
Mr. Pierce, whose responsibility is it to call the FDLE officers? I mean, it was your motion for discharge. So doesn't the defendant have the burden
of calling? Well, he has the burden to establish, or I'm not sure who has the burden of establishing each element. I'm pretty sure, though, for this point, they called the witnesses that they needed to establish it, right? So they called the defendant, and then they were able to elicit the information from the witnesses on the takedown team.
Well, whether he was arrested under the Duval County warrant is the issue, correct?
Yes, Your Honor. Yes.
Okay, and so take the third Melton factor. I think you've said that's one. I think number 1 and 3 are at issue, correct?
Yes, Your Honor. Okay. Yes.
So under the third one, the FDLE officers or the Suwannee County officers would have to communicate to him that he was under arrest for the Duval County warrant, correct?
Yes,
so
Your Honor.
At the hearing, the Suwannee County officers said they never told him that. And so other than your client's testimony, there's no other evidence that the FDLE officers told him that. Is that correct?
Correct. Yes, correct, Your Honor.
Okay. So I'm just asking if you had that position, why not call the FDLE officers? Why didn't your client call it, or why didn't the defense call the FDLE officers?
Well, I wasn't counsel for defense below. I'm not quite sure what their reason for not calling it was, but I don't think that they needed to or were required to, because what they needed to do was establish, they needed to present sufficient evidence to establish that the communication occurred. And here we have sufficient evidence that the communication occurred in the form of the direct evidence of the defendant's testimony that the communication occurred. This is also corroborated, albeit indirectly, by the fact that
so does your client's testimony contradict the Suwannee County officers?
No, Your Honor, it doesn't.
You don't think it does?
No, Your Honor. No.
Okay, why is that?
Well, because at the time of so the defendant testified that the communication occurred at the outset of this takedown, right? So the takedown begins, he's on the ground within seconds, everyone agrees, he immediately complies, and he testifies specifically, it's on page 278 of the record, that this communication occurred as he was going to the ground. And so the that establishes, or that presents sufficient evidence to establish when it occurred, and the fact that the Suwannee County officers, or let me rephrase this. The state's challenge to the sufficiency of that evidence, the fact that this communication occurred, is based entirely on the testimony of the Suwannee County officers who were running from 50 to 60 yards away at the time that the communication would have been uttered. And the problem for the state is that that testimony from those officers doesn't actually conflict with the defendant's testimony. Of course, they didn't hear it. They were running in full tactical gear from 60 yards away. And so because of the evidentiary posture that this presents, where we have sufficient evidence establishing the communication, and the only evidence that the state can point to diminish that isn't actually in conflict with it, it makes it all the sense in the world that they just wouldn't have heard it. Then
Counselor, can I interrupt you
Yes.
for a second?
Please.
Your client's testimony on that point is undisputed, correct?
As far as I'm aware, yes, Your Honor.
All right. And in terms of some of the documentary evidence, we have the probable cause affidavits and so forth. It talks about the arrest, and then the Suwannee County participation really is after the arrest. If
Yes.
you read the documents, am I looking at those correctly?
Yes, you are. They refer to it actually as a search incident to arrest. Yes, Your Honor. The search of him and his vehicle immediately thereafter. And so this is kind of the whole point, is that we have sufficient evidence establishing all of these elements. And the only thing that the state can point to challenge the presence of these elements is testimony that doesn't actually conflict with it. So on that communication point, again, there's
Counsel, I'm sorry to interrupt. Maybe you can
Yes.
help out on this third factor.
Yes, Your Honor.
Communicating by the arresting officer that this is an arrest. Now, let's say this exact same fact pattern happened, but the next day, someone tells your client, "Yeah, we were arresting you for this warrant in Duval County." Just in passing, just said, "Hey, the arrest yesterday was for the warrant in Duval County." Is that sufficient? And what I'm getting at is, does it have to be simultaneous with the arrest? When the officer comes up, grabs the person, arrests them, say, "We're arresting you for the Duval County warrant." It has to be simultaneous with it, and that's the only scenario, or can it be some other fact pattern? Because here, of course, you were relying at the hearing upon your client's testimony, but he also testified that he'd heard in the community in Jacksonville that there was an arrest warrant. And at some point in time, short after he was arrested by FDLE, he actually got a copy. He found out about the warrant, correct? So if you can kind of patch that all together and tell me how the law views it.
So I think that finding out it's the shorter answer is no. It doesn't have to be all at the same time. But the benefit of the current fact pattern is that we have both. We have both all at the same time and him eventually discovering it later. So the moment that all of those four stars or all of those four factors align, obviously the speedy trial clock would run. But I think you're also correct that he's later, if it's later communicated to him that he was arrested under this warrant, that also would be sufficient. And we have that here specifically, and this was the other point that I wanted to mention. Once that takedown starts, once he's on his way to the ground, and again, that's 278 of the record when he's saying this communication occurred. As he's going to the ground, at that moment, we have all four. I don't even think the state disputes that at that moment it was their intent to effect the arrest pursuant to the arrest warrant. We obviously have the seizure. We have the communication because, again, that's exactly when he says it's happened. And he was aware beforehand, the state acknowledged below, of the warrant. And so once that takedown happens, that's it. That's when the clock starts to run. And it does not matter what the Suwannee County officers testified that they observed after that point, because we already have all four. But as you were pointing out, even if they did, I do think a later communication would also suffice. I think the intention element of the first one is tied to the seizure, not to any other. So the fact that they were seizing him pursuant to the arrest warrant, it doesn't matter if they communicated it at that very moment, 20 minutes later, or the next day, that communication element could be satisfied later.
Again, on page 277 and 278, your client testified that I don't know how many times they said I was under arrest, but they did let me know I was under arrest for a warrant out of Duval County. That's undisputed.
Yes, Your Honor. That's my understanding. You're asking the question, so you're making me doubt. But no, there's no disputing that portion of it, because again, we don't have any testimony from the takedown team.
Well, and even disregarding the takedown team's testimony, what they may or may not have said, the Sewanee deputies who did testified that FDLE was there to effect the arrest for that warrant, correct?
Yes, Your Honor. This was a days-long focused operation. They wanted to arrest him on Friday, but they couldn't because of the concerts. They waited for him to leave. Their whole purpose this entire time for days was solely to execute this arrest warrant.
And the lieutenant from Sewanee County said that the FDLE ran the whole thing and they did the takedown. The Sewanee County deputies arrived after the takedown was complete, handcuffs on, and the FDLE agents were the ones who pointed out to Sewanee the drugs, the cash, and the gun, correct? Or guns. Is that right?
Yes, Your Honor. Yes, that's correct.
All right. So again, in terms of who made the arrest, it was FDLE. No dispute about that, correct?
Correct.
And the only reason they had to make the arrest was the Duval County warrant.
Correct.
And nobody testified that the arrest was for any other purpose.
Correct.
And nobody disputed your client's testimony that they told him he was arrested for that warrant.
Correct.
Okay. And do you like the Gilliam case pretty well?
Oh, I love the Gilliam case. I think it's very, very close. I think the only distinction between this and that is just that we actually have is who is giving the testimony about the communication. In Gilliam, the officer testified that he communicated that he was arresting the defendant under the arrest warrant. And here it's just the defendant testifying, but it's still just, we still just have to, it's still established through the direct evidence of the testimony of an individual, and no one contesting it, because no one in this case was there at the time.
Mr. Pierce, when you have two separate crimes like this, law enforcement can choose to arrest on which one they want, correct? And hold off on the other one?
Oh, sure. Well, in terms of like the charging decision later, or in terms of
Just in terms of arresting on a warrant or not arresting on a warrant. They have that option to, if they're arresting him on some other charges, they can choose not to arrest him on the warrant, on another warrant, correct?
Certainly, yes.
Okay.
Yes.
And so the trial court, he heard all this evidence and found that this was a detainer. So can you discuss that a little bit? The fact that the detainer was marked on the arrest warrant?
Sure. Well, I think again, we need to go back to the Melton element, because the element here is the intention at, and I'm tying this specifically to the takedown itself, but the intention was to, when they seized him, again, the Melton element, a purpose or intention to effect an arrest under a real or pretended authority. Here, that real or pretended authority is the arrest warrant. Now, the fact that law enforcement observes in the process of executing an arrest warrant other circumstances which would justify their seizure of the arrestee, that does not mean that law enforcement would then intentionally immediately abandon the authority and the objective of executing the arrest warrant in order to proceed solely with a warrantless seizure under the plain view doctrine. There's no reason that they just wouldn't do both. And the problem for the state in this case is that we have an overwhelming amount of evidence that this is the only purpose that they had in taking him down. Again, I don't think the state even contests that at the time of the takedown.
But this procedure happens a lot in law enforcement. You'll have two separate crimes. They choose to arrest on one and just put a detainer on the other until the other charges are completed, correct?
Yes, Your Honor.
Okay.
Yes. So with that said, I'll reserve the remaining amount of time for rebuttal.
All right, Mr. Welch.
Good morning, Your Honors. May it please the court, counsel. My name is David Welch, and I represent the state of Florida in this case. First thing I want to get to talk about standard here is there competent substantial evidence to support the factual decisions of the trial court here? And the first one I want to talk about is if the appellant was actually informed of the Jacksonville warrant or not during his takedown. And I would disagree that his testimony that he was told about the warrant is undisputed. When you actually look at the testimony of the Sewanee County officers, the first officer, and I think it's the lieutenant, I apologize, the name's redacted, but his testimony on page 240 of the record is that he was in his vehicle 40 or 50 yards away from the motel when the order to take down the appellant was given. He immediately got out of his vehicle and he said it took him about 10 seconds to get there. Now, I think it's a fair inference from this testimony that the FDLE SWAT team wasn't already next to the appellant when this order was given, that they were closer. But they, so we're talking, it took him 10 seconds to get there. FDLE got there at some point before that. And so within 10 seconds, he's at the defendant or at the appellant.
But counsel, if I can, I do mean to interrupt you, but I don't mean to be rude. That same passage continues by the lieutenant to say the FDLE agents already had the alleged defendant down on the ground by the time he got there.
Right, and the testimony was that as the FDLE was apprehending him, the defendant immediately complied and got to the ground. It only
But
takes.
and again, the undisputed part of it was where he said, I believe it was 277 and 278, that the FDLE told him repeatedly that he was under arrest and that he was being arrested for the Jacksonville warrant.
And Your Honor,
Whose testimony disputes that?
I believe both officers' testimony disputes that, because again, the defendant's testimony is he's being repeatedly told he's under arrest. And you gotta look at, the scenario is they're there initially for the attempted first-degree murder warrant out of Jacksonville. The testimony is all the officers had their guns drawn, and this was a tactical takedown. I think it's safe to assume that they're not using their inside voices at this point. It's a tense situation.
Counsel, I'm not asking you to assume anything. You said there's evidence that contradicts his
Well,
testimony.
yeah, so the evidence, the officer said he was there on scene in 10 seconds. The defendant's testimony is he's being repeatedly told that he's under arrest for a Jacksonville warrant. But then the lieutenant's testimony is he didn't hear anyone say anything about a Jacksonville warrant. So you wouldn't testify.
But he doesn't dispute what could have been said before he arrives, correct?
He does. I don't think he was specifically asked, was there anything that occurred that you didn't hear? So again, you'd have to be assuming at that point. But then the question is, does the evidence support the trial court's decision here? Not could the trial court have decided something else?
Well, counsel, I'm sorry to interrupt as well, but can't we assume the officer followed the law and the law required him to tell this individual that he was being arrested pursuant to a warrant?
But I mean, he was informed eventually that he was being arrested on the local charges.
But there's a statute that says that they have to make this statement at the time of the arrest under a warrant.
Right, but
So shouldn't we assume the officer followed the law, informed this individual being arrested for the Duval warrant? This individual testified to that effect. Everyone on the scene understood. There's no dispute in this record. Point me out to something that contradicts it. Everyone there in law enforcement totally understood this was an arrest to effectuate the Duval warrant, including these officers who testified from Swanee. So I'm struggling a bit by they weren't there, maybe didn't hear what was said, but all these other factors, the statute and the actual arrest warrant and so forth, those strongly suggest to me that the third factor is met.
well, Your Honor, I would dispute that the statute requires that they inform the defendant or the appellant in this case exactly why you're being arrested within the first 10 seconds. I don't think that's a requirement.
I didn't say that.
Yes, Your Honor, and that's what I'm saying. So I think it's, and if we all agree, like you said, it's undisputed. They were initially approaching the defendant because of the warrant out of Jacksonville. But as the case law makes clear, the initial detention doesn't automatically translate to a formal arrest for speedy trial purposes. So in this case, the testimony was in the process of initially detaining the defendant. And the testimony was there was a gun in plain view and there were drugs in plain view. And so during the detention, the local charges arose, and then he was ultimately formally arrested on the local charges. And there's no evidence outside of the defendant that says anyone said anything about the Jacksonville warrant. And just because testimony is undisputed does not mean that it's automatically accepted as true. So in this case, if the judge had actually accepted the defendant's testimony, then in theory, based on Gillum and some of the other cases, the judge would have found that all 4 Melton factors have been satisfied. But the fact that the judge said the evidence shows that the warrant wasn't executed until April of 2017 demonstrates the judge did not find the defendant's testimony to be credible. And we shouldn't be second guessing the judge's credibility determinations. He's the one who was there at the hearing, was able to absorb.
But he didn't make those findings. He didn't say that.
He said, I believe his.
In
He
fact,
said-
the trial judge, I don't believe, went through the 4 Mellon factors and made any findings as to any of them.
He made a finding in terms of, he said the evidence shows that the warrant wasn't served until April 2017.
Right, but that doesn't go to the Mellon factors. It dealt with the arrest years earlier.
Well, and then it's not, yeah, he did not go factor by factor. I mean, they argued the factors. And the dispute was the communication made of when the warrant was served? And again, you fall back to the testimony of 2 officers who were at the scene and said they didn't hear anyone mention the warrant versus the defendant's self-serving testimony that he was told repeatedly he was under arrest for a warrant. And then, I mean, that raises the other question. If all they said was a warrant without specifying the charges, I don't know if that necessarily satisfies that you've now been informed exactly what your charges are.
Counsel, let me ask you this. In the probable cause affidavit that the lieutenant did, and I think he may have done 3 of them, but in one of them, and I'm looking at his testimony on 253 of the record, it says, after the arrest of the defendant, the vehicle was found to have a concealed firearm. The probable cause thing may be at 107, but after the arrest was made by FDLE, correct? In terms of taking him into custody, putting him on the ground, putting the handcuffs.
I would say the initial detention was made by FDLE.
Right, and that's fine to call it that. I'm not trying to put more into it than there is. But the original detention, the reason for taking him into custody, the only reason to first have that encounter with him was because of the warrant from Duval County, correct?
Correct.
And as far as the Sewanee deputies are talking, or the lieutenant, he talks about after the arrest of the defendant, then we look in the vehicle, or then we're told about the vehicle, then we're told about the drugs and the firearm. So the arrest, according to the Sewanee County report, was the takedown by the FDLE, correct? I mean, in terms of their use of the term, is that how you understood it as well?
Well, their use of the language, that's true, but when the officer saying arrest versus detention isn't necessarily controlling in terms of a legal sense in this case, because one of the things is the formal arrest, and obviously the case law is clear, they don't necessarily have to have the bookend photos, the fingerprints and everything. But one of the things that serves is you've got to give notice to the prosecution authority that a warrant has been executed, because here you have FDLEs involved, you have Swanee's involved. Duval County's not involved whatsoever. They have a warrant out, but like Duval County State Attorney's Office doesn't know that this occurred. They have no.
It's not again, if we say that the Melton factors are what governs this case, and I don't think there's any dispute that that's what the law is, whether Duval County knew he had been arrested or for what reason is not a Melton factor, is it?
No, it's not. But what I was getting at is one of the things we need, though, is why you have, I think, a difference between a detention and a formal arrest for speedy trial purposes. I mean, case law, you have other cases where someone's been taken into involuntary custody on a suspicion, taken down, interrogated, and then released because they determined there wasn't probable cause. But again, the only reason they were ever taken down to the police station in the first place was for a specific charge. And ultimately, in the case law has said, involuntary detention does not equal automatic arrest for speedy trial purposes. It may trigger Fourth Amendment Miranda, but it doesn't necessarily trigger Sixth Amendment speedy trial. So you have.
You're not talking about Davis versus State by any chance, are you?
if that was the one, I think with the sexual assault where they cuffed him, took him down and interrogated him, I think it was 8 hours, and then ultimately released him. It was not the one, I apologize for not having these cases off the top of my head. It was not the case where they said if he had not agreed, I think it was a drug case where if he had not agreed to be an informant, they would have arrested him. It was one of the other cases where they interrogated him, ultimately decided they weren't going to arrest him on the charge that day, and he was free to leave at the end.
If the trial court had given us a finding that he did not accept the defendant's testimony, that he was told he was under arrest for the warrant, or that he was under arrest at all, would that change anything?
I think it would make the decision a little clearer, but I think in practicality, the trial court could not have accepted the defendant's testimony as true and made the decision that the trial court made. Because under Gillum, it's clear, I mean, case law, if you follow the Gillum case, if he had been informed, I'm arresting you based on this warrant, and then a subsequent search occurred, that would be good enough to trigger a speedy trial. But the only the testimony was, like I said, the lieutenant was on scene within 10 seconds, assuming FDLE got there sooner, but not immediately. Again, his testimony was no one mentioned the Duval warrant.
Well, counsel, if I can interrupt, we don't know. I mean, let's say the trial judge could have determined that this wasn't an arrest for purposes of speedy trial. It was just a detainer. Law enforcement then get to make a choice. And he didn't have to address the credibility of the defendant's testimony, correct?
Not necessarily, but then the question becomes, if
the question is my hypothetical. The trial judge here could have ruled as he did because he felt that there was not an arrest made. It was basically a detainer, a detention, and then a detainer.
Right, and then I think then the question becomes, is there competent substantial evidence to support the trial court's decision?
Right. So why didn't the state present the testimony of FDLE? Because here that would have, if they never said anything about Duval warrant and testified to that effect.
As my other counsel said, I was not the prosecution attorney on this case. So I don't know, it could have been that the FDLE agents weren't available that day. Potentially, there's any number of reasons why the state did not present testimony from the FDLE.
So Mr. Welch, back to the question that I'd asked opposing counsel, whose burden is it on this? Is it the state's burden to prove the motion for discharge, or is it the defense's?
I believe it's the defense motion, so it's their burden to show that speedy trial has occurred. The speedy trial has run, and then, and then obviously, if the defense can show that that's occurred, the burden might shift back to the state. So in this case, they had the state, go first for whatever reason. But again, it's the defense motion to show speedy trial, that he was unindicted and that the speedy trial, clock had started and then it had run.
Which of the Melton factors do you think we're missing here?
I believe 3, that the communication for why he was the communication by the arresting officer, the person whose arrest is sought, of the intention or purpose, then and there to affect the arrest for the Jacksonville charges. Again, because you had, it's undisputed that they were there because of the Jacksonville warrant. We're not disputing that.
So that's number 1. They had the purpose or intent to arrest him under the warrant. So that number 1's met, correct?
Right, and he was seized. He was actually detained.
Right. So number 2's met. Number 4 is met.
Number 4 is met if you believe the testimony of the defendant.
Well,
so 3 and 4 are basically intertwined. If you believe 3 didn't occur, then you reject the defendant's testimony for 4. If that makes sense.
No, it does. But again, under the 3rd factor, it says a communication by the arresting officer to the person whose arrest is sought of an intention or purpose then and there to effect an arrest. Period. It doesn't say for a specific charge, does it?
Well, I think you have to read it for a specific charge.
I think
Otherwise,
the speedy trial rule itself, I think, talks about for the charge. I think that puts a specific charge back in there, but as far as the Melton factors, it just says to arrest, to effect an arrest, period.
yes, Your Honor, but if you were to read it that you didn't have to say a specific charge in theory, if then you satisfy the Melton factors on one charge, if the defendant had other outstanding charges that were completely unrelated, then you could argue that, well, the speedy trial clock started. And that's why it comes to specific charges, and that's why it's important here. And again, it sounds like there was some kind of miscommunication between Swanee and FDLE in terms of who was taking the lead. But it appears.
Really? Can you tell me where there was any kind of dispute over who was taking the lead in this takedown?
Well, not in the takedown. I think it's obvious that FDLE led the takedown, but then they just handed the appellant over to Swanee to take care of the local charges. And Swanee and I think the miscommunication is Swanee just assumed like, okay, well, FDLE is going to take lead on the Jacksonville warrant, and then FDLE didn't do that. And so that's where I think the testimony where the officers were stating why they mentioned the Jacksonville warrant in their write-ups the next day.
All right. I think the testimony from Swanee was eventually the FDLE turned him over to him. It wasn't like they grabbed him and immediately passed him over. I mean, the testimony of the state's witnesses was that it was eventually, it was the FDLE operation from the start. They took him down, they passed on the information, and they eventually turned him over to the local authorities. I mean, do I have that right?
And I think and it goes back to FDLE detained him. And it comes down to, and the case law is very clear, involuntary detention does not automatically translate to a formal arrest for speedy trial purposes. So FDLE detained him. It sounds like he was initially in FDLE custody. And I don't know if the turnover occurred at the scene or back at the Swanee PD headquarters. But that's where he was formally charged with the Swanee charges of the gun. And I know one of your honors was asking about the gun that they eventually found in the car after the fact. I just remember that.
Counsel, I have a quick question before your time runs out. What's the state's position on whether in a situation like this, whether if, for example, the state, if, for example, the officer says, I'm arresting you for a warrant, doesn't say Duval County, I'm arresting you for a warrant, is that sufficient for speedy trial purposes? And secondly, if this same fact pattern happened and this gentleman, Mr. Robinson, was then told the next day your arrest was due to an arrest warrant out of Duval County, does that, from the state's view, does that meet the Mellon test for speedy trial purposes? Those two situations.
Right. So the first one, if they just say warrant, potentially not. Again, it would go on to this specific fact pattern, but purpose of speedy trial is, now that you've been charged with this specific charge, we're going to take you to trial. We're telling you we're going to take you to trial within a specific amount of time. If you just say, I've just arrested you for a warrant, if you potentially had warrants in two separate counties, for example, on two completely unrelated charges, does that automatically then trigger both warrants if in a fact pattern that the arresting officer had no idea about the second one? Or even if he did, he meant that he was arresting him on one warrant, that he knew of the other warrant, but didn't mention it to him, didn't have any intention to mention to him, then potentially I would argue that speedy trial is not triggered there. On your second example, if they say, we also have this additional warrant and we are formally arresting you on it, then yes, that would trigger it. But just because you're aware that another warrant exists and potentially in discovery or whatever, like in the case is clear that Duval County ended up putting a detainer on the defendant, and the defendant, if he became aware of the detainer, that won't trigger speedy trial, even if he was aware of it and got a copy of it. Because at that point, Jacksonville's like, hey, so you're aware this warrant exists, and let us know when he's gonna get released so we can go formally arrest him on it to start the process.
And I've got another question here, and don't worry, Mr. Pierce, we'll give you a little extra time if you need it as well. Under Rule 3.191D, it says custody. For purpose of this rule, a person is taken into custody when the person is arrested as a result of the conduct or criminal episode that gave rise to the crime charged. How is that not what happened in terms of them taking him into custody, detaining him, taking him down, whatever? I mean, doesn't that fit?
Not in this case, Your Honor, and that goes back to the fact that involuntary detention, which I think anyone would consider custody, does not automatically trigger a speedy trial. So in this case, I believe what the state's position occurred is he was initially approached because of the Jacksonville warrant. And in the process of initially detaining the appellant is when the pistol, I believe it was a pistol, was seen right next to the appellant on the ground. And then you have the drugs in plain view. And that those then intervened, if you will, and the Swanee ended up taking lead. And so he was initially detained, but then he was formally arrested on the charges that arose during that detention before he was informed of the Jacksonville warrant.
All right. Do either of my colleagues have more questions before we turn it back over? All right. And so you get another 2.5 minutes if you need them, but we'll just add that on at the end.
All right. Well, I'll still try to be brief. First, there were opposing counsel mentioned several. He said that we could infer some findings into the record from the court's ruling.
Mr. Pierce, let me ask you. Judge Edwards had asked about this rule of procedure. So typically under this rule, if there's a violation, normally you'd file a notice of expiration as speedy, which wasn't done in this case, I don't think. And then there would be a recapture period before there would be a discharge. But the Supreme Court has basically interpreted this rule as a pretty hard and fast rule at 175 days of no information is filed. They almost treated it as a statute of limitations, correct?
That's my understanding. Yes, Your Honor.
Okay, but there was no notice of expiration of speedy filed here and no opportunity for recapture because of the Supreme Court's decision. I think it's been almost 20 years ago. Is that correct?
I believe that's correct. Yes, they just didn't file.
Okay.
So just to refer to the point, I don't think we can infer what the state wants us to infer, what the state needs us to infer from the court's ruling, because as Judge Maker pointed out, the court did not address any of the Melton factors. And so I don't think we can take the court's ruling, which isn't addressing Melton at all, and then try and infer from those rulings the factual findings that would support each of the Melton factors, because that's clearly not what the court was doing. I'd go further, though, and to say that even if we had an express finding on the record in a written order saying that I don't find the defendant's testimony that this communication occurred to be credible, I would argue that there's insufficient record evidence to support that conclusion, because this testimony, the specific testimony, the only testimony that's actually disputed, and again, the state did not dispute the other aspects of the defendant's testimony that his wife had told him before. They accepted that below. The only aspect of his testimony that they're disputing is this communication. And that one thing that occurred is what's required by law. And so there's no reason to rule or to find that testimony to not be credible. Secondly, I think there was some mention over whether or not the communication itself was disputed early on. I'd like to point out that there were there's two officers coming from the support team. The first officer that testified gets there first. He gets there before the second one. And on 252 of the record, I believe, and this is in response to Judge Edwards' question earlier, can you say that that did not happen, referring to the communication, or you don't recall it happening? 5 years ago, I don't recall that being said around me. Okay, but you can't say it did not happen is my point. I cannot say no. I know I didn't say it. So the guy that gets there first can't say for sure that it didn't happen. And then the other officer gets there after him. So no, there is no dispute over whether or not this happened, or there's no evidence to say that there's a dispute. There's not a credibility battle here. This isn't a matter of choosing who to believe. You can believe both. And the only conclusion that you can draw from the evidence that was presented is that that communication element was met. And so lastly, I'll just close by saying I think this case is nearly identical to Gilliam, as I pointed out earlier. We have sufficient basis to find each of the Melton factors, and the only challenges the state can raise to those factors is based on evidence which does not actually conflict with or even tend to rebut the establishing evidence. So based on that, on the arguments we made in the initial brief and today, I would request this court reverse and vacate his judgment and sentence and remand for discharge.
Thank you very much. A very interesting case, well argued and well briefed, and we will be in recess. Thank you.